Good morning, everyone. I'm Judith Roberts and I'm the chair of the Scottish Human Rights Commission. And we have a few more people who will be arriving in the next 20 minutes, half an hour, but we're going to start because we have a lot to get through today, and I'm very happy to see all of you here. I think we're in for a very interesting discussion and session. As I said, I am... Now, there will be a fire, just a couple of housekeeping pieces. There will be a fire alarm this morning. If it lasts anything more than several seconds, it is a real fire alarm. I'm not expecting it to, so let's hope that doesn't happen. But don't pick up your bag and run if it goes off, as it will. I think if you haven't found the toilets, they're all out there on the landing. The emergency exits are just out there. You'll see the green signs, and it's downstairs and outside. So hopefully we won't have to do that. So as I've said, I'm from Scotland's, from the Scottish Human Rights Commission, Scotland's National Human Rights Institute, with a mandate to promote awareness, understanding and respect for human rights in Scotland, and a mandate in relation to all devolved areas in relation to Scottish Government and Parliament in Scotland. We're delighted to have you here today in what we hope will be a thoroughly stimulating session that advances all of our thinking about how Scotland can be a leader in the protection and implementation of human rights, especially economic and social rights. This year marks the 10th anniversary of the Commission, as well as the 70th anniversary of the Universal Declaration of Human Rights. And just as we've been looking back on that time and reflecting, it's clear how far we've come in the 10 years and indeed in the 70 years as we talk about and understand human rights in Scotland. 10 years ago, when the Commission began its work, human rights debate was often confined to issues of detention, criminal justice and to compliance with the European Convention on Human Rights standards and civil and political rights. The notion of taking a rights-based approach to law and policy design and implementation was an enigma to many public bodies, and UN treaty body recommendations rarely, if ever, found their way into political debate. Since then, we have generally seen a progressive direction of travel towards a broader and more informed understanding and respect of international human rights law standards. And importantly, an appreciation of the indivisibility and interdependence of all rights, civil and political, as well as economic and social. About how if people can't access adequate housing or healthcare, their ability to vote or exercise freedom of expression or assembly or to live life of human dignity is in fact imperilled. So we all have all the rights, and all the rights impact on all of the others. We've also seen a growing understanding of how human rights standards can both inform and support decision-making in all settings, from the Parliament to care homes, with local authority housing officers and prison officers. And we've seen how so many actors, both duty bearers with responsibilities to respect, protect and fulfil rights, as well as rights holders, have coalesced around Scotland's National Action Plan on Human Rights to show their support for human rights and tried to collectively come up with solutions to rights issues in Scotland, from stop and search by the police to the adequacy of social housing and care setting standards frameworks. It was through SNAP, indeed, that the Commission, together with the Government, held an interaction in 2014 on addressing poverty through human rights. And following on from that, an innovation forum in 2015 on the incorporation or legal embedding, as we will be discussing today, of international standards. At that forum, the First Minister engaged with the notion that we can do more in Scotland to embed economic social rights into the work of government. That was given further stimulus and impetus through the ongoing debate about the repeal of the Human Rights Act and replacement with the British Bill of Rights and the impact of Brexit on our rights framework. Further commitments have since been made by the Scottish Government to consider how economic social rights can be embedded, as well as the option of full incorporation of the Convention on the Rights of the Child into domestic law. So at the end of last year, the First Minister appointed an independent advisory group to make recommendations on how Scotland can be a leader in human rights, including economic, social rights and environmental rights. The Commission is pleased to be part of this advisory group, chaired by my predecessor, who's sitting over there at the Commission, Professor Alan Miller, and some other members of the advisory group are also in the room today. As that group forms its recommendations by the end of the year, it's clear that the incorporation of economic and social rights into Scots law is being given serious consideration. There is then a discussion to be had about what human rights standards we want to see embedded in our domestic law in Scotland. What rights do we value? How are they best protected? What are the benefits of legal protection and what are the pitfalls? What are the implications for our lawyers and judges, Parliament and Government? The Commission, in its role as Scotland's NHRI, aims to bring together a broad range of actors to engage in this debate and equip people with the understanding and knowledge of global best practice in this area to ensure our deliberations are informed and outward-looking. As part of this process, we've held 4 thematic workshops over the course of the year looking at some of the individual rights within the economic covenant on economic and social cultural rights, the right to housing, the right to food, the right to social security and health. This workshop is the concluding part of that series of workshops and is intended to look specifically at the issue of justiciability of economic and social rights and indeed other international standards. So today we will explore all these questions. Why incorporate international human rights standards? What are the challenges? What are the different models that Scotland could apply? And what else is happening elsewhere in the world? We have a really diverse mix of people in the room today. It's really, when we're really pleased to see that. That was our hope, and that's been fulfilled. About a quarter of you are from the Scottish Government in different bits of the Scottish Government. 1 in 10 is from the Scottish Parliament, so you can check out where people are from. Another quarter of you are from civil society organisations. You know who you are. And again, we have some people from about 1 in 5 of you is academics. I'm doing a quick translation from percentages to easier numbers. And then another 1 in 10 of you are from the legal sector more broadly. So we have a really good mix of people, and as I say, we're really pleased to see that. Thank you for that. I'm now just a couple of other words. We are very keen to have people tweet about the session. It's incredibly important that the messages from today are communicated more broadly than to those of us in the room. We are filming the speakers. We're not filming the table discussions. So you won't. None of your conversation will be broadcast more broadly. We please feel free to tweet what the speakers are saying and indeed your thoughts on that, but don't tweet the table conversations. They will be Chatham House rule conversations. So we've got a diverse mix of input today, really rich, but we're keen to communicate that more broadly. And the film from the workshop will be available ultimately from the Commission on the website for a wider audience to see and share. So that's it from me to start with. I'm now going to hand over to Kavita Chetty, who's our Head of Strategy and Legal at the Commission. She's going to introduce you to some of the discussion points today.
Thank you, Judith. So my job this morning, I'm going to build on Judith's introductory comments to try and essentially bring us all to the same page. As Judith said, there's a really diverse range of people in the room today, which is great, but you obviously all come with different starting points. So I'm just going to set that sort of baseline for today's discussion. So to warm you all up and have you engaged, if you could please all take out any smartphone, tablet, laptop, whatever you've got that you can access the Wi-Fi of the hotel. It's McDonald Holyrood is the Wi-Fi. I'll give you a moment to do that. And when you're on the Wi-Fi, go to www.menti.com. So it's on the screen, www.menti.com, and if you can connect to the Wi-Fi, so I'll just give you all a moment to do that. When you get onto menti.com, you can enter the code 562334. It's 562334. Just give me a nod so I know when people are... Yep, people are generally on. Okay, great. Okay, so I'll just take a moment for that to come up on my screen so I can see where you are. Thanks, Ali. 562334. One last time. Okay, great. Okay, so when you're on there, I'd like you to first of all just enter 3 words, phrases that you think about when you think about economic, social and cultural rights. So anything at all that comes to mind when I say economic, social and cultural rights. What do you think of? What rights, what concepts, what issues, anything? Ali, I think we've lost our connection somehow on the... Great. The dangers of relying on technology for your introductory presentation. Great. Okay, great. So we've got a variety of things, which keeps moving, which makes it very hard for me to reflect on. So we've got a number of rights referenced there: education, health, social security. Justice is coming up quite strongly, so the larger words are the ones that are coming through from more of you in the room today. Justice, poverty, the idea of equality across all of these rights. Let's try and pick up some of the smaller ones if I can. Aspirational, interdependence, ordinary lives, unequal access. Some of the smaller ones are quite interesting. Social justice. Okay, we're going to pick up on a lot of this today. We're going to pick up on the rights themselves, what they are, what some of the legal norms that sit behind those rights look like. We're going to pick up on some of these challenges around them being, for example, aspirational. Are they just aspirations and political commitments, or can they be something more than that? Can they be justiciable rights? And some of these underpinning concepts of fairness, equality, and the idea of a progressive is one word that's come through there, a progressive vision of social justice and a way of addressing poverty. So we'll pick up on much of this throughout today. I'm going to move now to the next question. What proportion of children in Scotland do you think are living in relative income poverty after household costs? So you've got some, you can vote here, 14%, 67%, 23%, 8% or 45%. Proportion of children in Scotland living in relative income poverty. How's our connection lost? I'm not seeing your votes coming in, so something's gone wrong. We did, this was tried and tested. Okay, so 64%, 65% of you guessing 23%. So yeah, 66% of you in the room are right. The answer, according to the Joseph Rowntree Foundation 2017 report on poverty in Scotland, the 2013-16 figures was 23%, which is slightly less than the UK average of 29%. Now, I really choose this as a purely illustrative statistic, as a proxy to show the scale of the issue of poverty in Scotland, with nearly a quarter of Scottish children affected by that statistic. But these poverty measures related to income clearly give us a very partial story, and they don't recognise either the causes or the consequences of poverty. And a rights-based definition of poverty recognises poverty as multi-dimensional. So in a statement from the Committee on Economic and Social and Cultural Rights, of which Virginia is chair, adopted in 2001, they define poverty as a human condition characterised by sustained or chronic deprivation of resources, capabilities, choices, security and power necessary for the enjoyment of an adequate standard of living and other civil, cultural, economic, political and social rights. So this definition of poverty allows us to see it both as a cause and a consequence of human rights violation, because people in poverty face many obstacles in accessing their rights entitlements to education, to housing, to healthcare and to work, as well as their political participation. And so each of these is really, as Judith said, closely interrelated. So, for example, a lack of adequate housing severely impacts on the right to health, to education, to the ability to gain employment and work, and even then to vote, and so on, one deprivation impacting on the next. So they're interrelated and they're mutually reinforcing deprivations. And this is why economic and social rights can be so important in the fight against poverty, because they recognise poverty as multi-dimensional in nature. And importantly, they confer obligations on the state, the duty bearer, and they empower the individual, the rights holder, with entitlements. And the rights framework explicitly recognises these various sources of poverty: food, housing, health, education, as well as the discrimination and the social exclusion that occurs as a result of poverty, and tries to address that through the framework. So we also know that these are the rights that really matter to people here in Scotland. And time again in the Commission's work, when we go and speak to people, we find that these really are the rights that people are most concerned about in their everyday lives. In 2015, the Commission commissioned YouGov to carry out some research for us to have some insight into what people in Scotland thought about human rights. So moving on to the next question. Sorry, this is really tiny on the screen, but I'm hoping on your smartphone or tablet it's a bit bigger. I'd like you all to guess which of these statements resonated the most strongly with all participants in that research. So that goes from those that were highly committed to human rights to those that were much more sceptical. And the four statements are: we all have the right to an adequate standard of living. That means things like decent housing, healthy food, and enough money to live on. First statement. The second statement is: respecting values and principles like equality, freedom and fairness is good, but having rights to protect and preserve these values is better. And the third statement: no matter what happens after Brexit, Scotland can still be progressive and bold when it comes to protecting and realising human rights. And the fourth statement: human rights belong to all of us. Everyone needs human rights to be able to live with dignity and freedom. So I'll let you vote on which ones you thought were the best received. So I should say that all of these statements were actually relatively well received, to be honest, but the ones that were most well received... Yeah, indeed. The first statement, we all have the right to an adequate standard of living, was one of the most popular statements. That 35... not percent, that's 36 of you have voted for. And the next favourite actually was the Green, that no matter what happens after Brexit, Scotland can still be progressive. Was that, surprisingly maybe, the second most popular statement. So they recognised these rights of housing, food, money as important to them, and they were looking for a progressive human rights future in Scotland. Now, what is quite interesting to me is that the first statement, the second part of that statement was that it's the government's responsibility to make sure these rights are realised for everyone. Now, I deprived you of that because it was too much text for the box. But what's interesting about that is that there was a recognition not only that we have these rights, but those rights come with responsibilities on the state. And so there's a question then for me about where you've got responsibilities, where does that come with accountability? Where is accountability? Because, after all, accountability is the cornerstone of human rights, because fundamentally it defines that relationship between the rights holder and the duty bearer, and it challenges power dynamics by holding those in power account for their decisions or actions, or indeed lack of actions. So when it comes to economic, social and cultural rights, this question of accountability has historically been quite challenging, much more so than civil and political rights. And this is because the nature of the violation is often systemic, with multiple factors, multiple causes, often due to weaknesses or bottlenecks in the system, or different policy areas not speaking to each other, or how they're being implemented. So it makes it hard to define often who the rights holder is, and it makes it hard to define exactly who the duty bearer is and what the nature of those responsibilities are. But there has now been decades and decades of work done by the treaty bodies, the UN, done by courts, done by national parliaments, civil society organisations, national human rights institutions across the world, which mean that we're now in a much better position, really, to hold government accountable for economic and social rights violations through better monitoring, better measurement, and ultimately stronger judicial protection of those rights. And I really hope that throughout the course of today, that will become more and more clear. Okay, next question. Can you give in a word, a phrase, an example of how the UK and Scotland are held to account for the implementation of international human rights, by which I mean the rights that come from the UN treaties, so the Convention on the Rights of the Child, Convention on the Elimination of Discrimination Against Women, International Covenant on Economic, Social and Cultural Rights, etc., etc. How presently do you think government is held to account for these rights? UPR, wow, that's come up really big, that's great. Oh, okay. Okay, UPR's come up a couple of times, UN committees, courts, parliaments, votes, reports. Media has coming up a few times in different ways. There's actually quite a lot there in relation to the UN supervisory jurisdiction, but also at a national level, Parliament, political pressure, getting more and more, public opinion, civil society advocacy. I'll read some of the smaller ones so that you can all see. Statutory obligations. So a whole wealth of ways in which currently government is held to account for international treaty body recommendations. So we can see from those word cloud responses that there are a whole variety of mechanisms. Some of them are formal, some of them are informal, some of them are at an international level, some of them are at a regional level, some of them are very local, and they all really interplay together and enforce each other. So we need to think about how we can draw on each of them and how they relate to each other. And they're not, of course, all about just being corrective measures. Some of them also play a sort of preventative role to address what's going wrong at the outset in order to address it and provide a better outcome for people. So what I really wanted to make clear is that accountability is not only about going to court. It's really about building up the systems in the design, the delivery and the implementation of law and policy to ensure that rights are met. But the access to justice and a remedy and enforcement is core to human rights, as I said earlier, and core to a human rights-based approach. Now, on work done around this concept of accountability in sort of public governance, you can break down this concept into three areas. The first area is responsibility. So in order to hold a state body or anybody to account, you need to know what is it that they're responsible for. Now, international law clearly gives us a good idea of this. And as I said earlier, there's been much further elaboration on those standards in international law, for example, by the UN treaty bodies through their general comments. But it's recognised that in many senses, the strongest ownership of that can come at a domestic, local level, where there can be much further concrete normative elaboration on what the standards actually are. An incorporation of the rights, by which I mean an embedding of those rights into our national law, can assist in that process of elaboration, of identifying what is it that the state exactly is responsible for. The second component of accountability is answerability. So one of the things we expect is that there's reasons and justifications and transparency in actions and decisions that are taken. And this is core to, of course, a human rights-based approach. and legal obligations at a national level can further sort of confer that justificatory obligation on decision makers. A point that Katie will come back to later today in her remarks about how national parliaments can enhance their scrutiny role to cover economic, social and cultural rights. And the third component then is enforceability. So when there is a breach, when there is a violation, people have access to remedy through courts, through tribunals, through ombudsman, etc., or other review mechanisms. And that will be the focus of today on this enforceability and justiciability of international human rights law standards. Okay, so moving to the next question on those legal standards. Which of these rights are not expressly protected by the Human Rights Act 1998? So the Human Rights Act 1998, which put into our domestic law the rights from the European Convention on Human Rights. Which of these rights are, okay, it's actually too small for me to read, are not covered? I can't read it from here, I might have to.
That's the right answer.
Yeah, thanks, I can't quite read that. So, yeah, on the face of it, it looks like, yeah, I can just about see. Okay, we have a very informed audience today, so that's great. That's right, so the right to social security, the right to independent living, the right to adequate housing, the right to the highest attainable standard of physical and mental health, the right to food are not expressly covered by the Human Rights Act. Now, I should say, before any particularly pedantic lawyers in the room get cross with me, it is true to say that aspects of these rights are, of course, absolutely covered by the European Convention on Human Rights and the Human Rights Act. So, for example, although the right to social security isn't explicitly mentioned in the European Convention, the European Court of Human Rights in Strasbourg has made clear that social security does fall within its ambit. For example, in procedural aspects related to your process of claiming the right, engaging Article 6 and your right to a fair hearing, and also in a substantive way where the court looks at the content of the right and has found certain benefits to be protected by the right to property or the application of non-discrimination, and in limited cases, even assessing the amount of payment as insufficient to meet the requirements of Article 2 and the right to life, and Article 3 and the right to be free from inhuman and degrading treatment. So it is clear that dynamic interpretation of these so-called civil and political rights can give protection of an economic and social rights nature. But what is also clear is that doesn't in any sense cover the full spectrum of the right as covered in international law, where, for example, in relation to social security, if you look at the right as set out there in the Covenant and then the elaboration on that right from the general comment, which Virginia was key in drafting, it covers a much larger normative content, including the availability, the adequacy and the accessibility of the right to social security. And we'll return to that point later around the normative content of economic, social and cultural rights later this morning. But the point that I'm really making here is that there is a clear legal accountability gap in Scotland when it comes to economic and social rights, despite their importance in people's everyday lives. So the next question: what powers do the Scottish Government and Parliament have in relation to international human rights law? What powers do the Scottish Government and Parliament have in relation to international human rights law? So the answer is to vote on being none. International obligations are reserved. 2, it's outside of their powers to legislate incompatibly with international human rights law. And 3, observe and implement international obligations, including human rights. Okay, so again, that's great. We've got a really pretty... Oh, okay, no, votes are going up. Let's wait and see. Okay, yeah, so most of you in the room are right that under the Scotland Act 1998, which established, of course, the Scottish Parliament and devolution of power from Westminster, there's provision for Scotland to observe and implement international obligations, which means that it is within devolved competence to legislate for the protection of international human rights obligations. It's made clear that it's certainly not their obligation to do so, but it is within their power to do so. So although the UK isn't clearly the state party that signed up to these international treaties, the devolved government and legislature nevertheless carry responsibility and have competence to go further to protect these rights that are currently missing, as we demonstrated from our human rights framework. And there has, as Judith alluded to in her opening remarks, been an increased recognition and regard had to these international standards, and also more generally when it comes to accountability for socio-economic rights in Scotland. So, for example, we've had the enactment of the Fairer Scotland duty or socio-economic duty that means that public bodies have to take into account socio-economic inequality gaps in their strategic decision-making. And we have, for example, the establishment of the Poverty and Inequality Commission with a role to monitor progress against targets. And there's also an explicit increased recognition of the UN treaty standards in themselves as an accountability tool for guiding, in principle, law and policy. So, for example, under the new social security legislation, there'll be a social security commission with an overarching scrutiny remit that must have regard to international law standards in the performance of all of its functions. In recent years, we've also seen explicit reference to the International Covenant on Economic, Social and Cultural Rights in domestic law, for example, through the land reform legislation, where the Minister has to have regard to the desirability of economic and social and cultural rights in its Land Rights and Responsibility Statement, through the Community Empowerment Act 2015, where in making decisions under the Act, Ministers also have to have regard to ISESCR, the International Covenant. And there's been a lively debate around the enshrining in full of the right to social security in legislation, and there's highly likely to be a future debate around the embedding of the right to food in framework legislation on food governance. It's also definitely worthy of note that in terms of increased accountability, that the recently revised National Performance National Outcomes Framework, to be laid before Parliament this week, explicitly includes an outcome to protect, respect and fulfil human rights and live free from discrimination. And we've seen the Equalities and Human Rights Committee has been very active in considering how they, as a parliament, can embed human rights and consider international obligations. So there's a clear direction of travel and momentum behind this debate that we're having here today. We've got the strong signals of commitment from the First Minister and this ever-evolving dialogue about the place of international human rights law obligations within our governance in Scotland. So there are many reasons for us to take this forward and very carefully consider this question of incorporation. First and foremost, as I said earlier, ultimately this is about giving access to justice for individuals experiencing violation of their rights and strengthening of accountability for those rights which, as I said at the outset, all too sadly we know are not always met in Scotland today. And secondly, and really critically, as I said earlier, what flows from that is a greater embedding of all rights into law and wider policy and decision making, because all of those decisions are then taken in the shadow of that backstop of protection that incorporation can give. And of course then we would have a more comprehensive legal framework of protection for rights that recognises that indivisibility and interdependence of rights, and that without freedom from want, without freedom from need, then we can't have really the other freedoms that are given under the human rights framework, and we become much more vulnerable to their violation. And finally, it would show a willingness to engage meaningfully and constructively with the recommendations coming from the UN treaty bodies, who have a supervisory jurisdiction in relation to compliance with the international obligations. And year after year, we've seen the committee make the recommendation to the UK as the state party to incorporate economic, social and cultural rights into its domestic legal order. So it's really on that note that I want to pass back to Judith to introduce our next chair, the chair of that committee, the UN Committee on Economic, Social and Cultural Rights. But before I do that, just one last question on the Mentimeter. What are your views now, really? What are your views on incorporation? And there's a sliding scale response from strongly agree to strongly disagree. So do you think that the Human Rights Act has all the protections that we need in Scotland? Agree or disagree? Do you think that the legal framework should go further and protect a broader range of rights? Do you agree or disagree? Do economic, social and cultural rights do not lend themselves to becoming enforceable in law? Agree or disagree? And there are positive lessons we can learn about the incorporation of economic and social and cultural rights from around the world. Agree or disagree? I'm interested in your answers. Okay, so we've got a few of you who think the Human Rights Act. I don't know if that's 1% or 1%. I think it's 1%. It must be a percentage because we don't have half a person in the room as far as I'm aware. Okay, so what's that? Yeah. It's on the scale. Sorry, I'm seeing the scale. Okay. So we have some people that think the Human Rights Act have all the protections we need. Generally, we're on the high end of thinking that we need to go further and protect more rights. We've got a few people who are concerned that the nature of the rights doesn't lend themselves to being enforceable in law, but almost everyone in the room thinks that we can learn lessons from international experience. So we hope to bring you some of that international experience throughout the day. So as I say, on that note, I'll pass to Judith to introduce our next speaker. Thanks.
Great. Thank you very much, Kavita, for that broad introduction of the conversation we're going to have. I'm really now absolutely delighted to introduce Virginia Bras Gomes, who's the chair of the UN Committee on Economic, Social and Cultural Rights. She comes to that position with a considerable and clearly many years of contribution on a range of key issues, some of which are very relevant for our current work here in Scotland. She was the co-rapporteur of the committee's General Comment number 19. We are the biggest fans of the General Comment number 19, which I have to say Virginia has been delighted to see, on the right to social security, and on General Comment number 23 on the right to just and favourable conditions of work. Something which I know many people in this room will be very pleased to hear. She's also a senior policy advisor in the Ministry of Employment, Solidarity and Social Security in Portugal. She's a member of a number of international boards and advisory groups relating to social and economic rights of women and children. So I actually can think of nobody better, in fact, to inform us and really welcome Virginia's contribution to today and the time she's taken to come and make this contribution for today. So I'm going to hand her over to you.
Does this work? Yes. Thank you, Judith, very much. More than delighted about the Social Security comment. I think I'm moved by the fact that people are using it, because sometimes I have a feeling general comments really apply to a very restricted audience, and that's a pity because they're supposed to provide guidance. So I was really moved by the fact that General Comment 19 has been used as a training tool. It has been used in awareness-raising efforts. That is my first comment. My second comment is that I'm really sorry I don't have a quiz for you, because I think coming after Kavita I'm going to sound terribly boring and dry. But, well, to each of us his or her own role, and I will try my best. And I wish to thank the Scottish Human Rights Commission very much, and Judith and Kavita and Katie and everyone who's been involved, and Laura and everyone who's been involved in this effort. For this invitation. I'm really looking forward to a day of discussion, not so much about what I will say, but a lot more about what I will hear from you, because this is a very special moment in Scotland, I would say, after the Social Security debate, that I followed with some interest after having read a first piece of news on The Guardian, and then I kind of said to Kavita how glad I was, and then Kavita alerted me to some finer issues that the Guardian news didn't really have very clear. So I'm looking forward to the continuation of that debate. Well, we'll come to that later. So I'm glad to be here for a number of reasons. First of all, these two interrelated issues of incorporations and justiciability are of paramount interest to the work of the committee, so far as both have a direct impact on the realization of covenant rights on the ground. And from our experience, unfortunately, advances made in both fields are far from satisfactory. So every opportunity to further pursue the relevance of both requirements at national level is most welcome. This is also, I think, a good moment to reiterate the value of the core human rights treaties. And the UK has ratified 7 out of the 9. It's a good time to kind of highlight the value of these treaties in the Brexit and post-Brexit context. And last but not least, the committee welcomed the engagement of the Scottish Human Rights Commission at the time of its last dialogue with the UK in 2015. And the very useful report it provided, both the background information and the potential questions to the national delegation, were very useful. And I do hope our concluding observations did justice to at least some of the issues raised. Our committee is looking for opportunities to strengthen its ties with national human rights institutions, not the least because of our recently instituted follow-up procedure regarding concluding observations that deserve priority attention. Unfortunately, the procedure was adopted after the UK presented its 2015 report, but it will certainly apply in the next reporting round. When we think of economic, social, and cultural rights, it's important that we go back to the human rights vision that is so beautifully spelled out in the Universal Declaration. And I think being the 70th celebration of the 70th anniversary is a good occasion to bring it up again. And this vision is captured in the 4 freedoms: freedom of speech and expression, freedom to worship in his, and of course I would add her own way. At that time, it was all in the male way of speaking, but I think it's good that it's his or her own way, freedom from fear, and freedom from want. And this last freedom is widely interpreted as a synthesis of economic and social cultural rights. Now, then we had the UN World Conference in 1993. At the time, there were 171 UN member states, and everyone agreed. It was unanimously proclaimed that the international community must treat human rights globally in a fair and equal manner, on the same footing and the same emphasis. So in terms of the international human rights discourse, the bridge had been crossed, but unfortunately, the materialization of the statement did not follow suit. And economic, social, and cultural rights are still placed in a subsidiary position to civil and political rights. And perhaps the best example of this unequal status is the lack of incorporation of the covenant in the domestic legal order of many states that have ratified it. In our dialogue with states, when they're confronted with this unequal status given to economic, social, and cultural rights in relation to civil and political rights, and on how this fails to comply with the basic principle of indivisibility and interdependence of all human rights, a common response is that economic, social, and cultural rights, while not being considered as fundamental rights, are directive principles of state policy that ensure, if not the same, at least a comparable degree of protection as for civil and political rights. Now, part of the argument for this hierarchy of rights, states tell us, is that the principles of universality, indivisibility, interdependence, and interrelatedness of all human rights do not imply equal implementation. And this provides a justification for economic, social, cultural rights to be viewed as effectively second-class rights, aspirational. We also heard some people talk of the aspirational nature of economic, social, cultural rights. Therefore vague, unenforceable, non-justiciable, given their imprecise content, only to be fulfilled progressively over time. This is one side of the argument. The other part of the argument is that the direct applicability of the covenant rights is incompatible with the doctrine of the supremacy of the Parliament. In other words, if these rights were to become the basis for judicial decisions, judges would be entitled to enter the realm of politics, which is reserved for Parliament. Just as a footnote, it would be fair to add that even states that have incorporated the covenant do not provide significant examples of case law where it was invoked. One justification offered is that the rights are already protected constitutionally, and therefore there's no need to invoke specific covenant provisions. But there may be other factors, like lack of knowledge about the covenant and the misperception that international norms on economic, social, and cultural rights are not self-executing. Fortunately, against this artificial decision of human rights into first-class rights that ensure the freedoms and second-class rights that are mostly aspirational, there is jurisprudence of many constitutional courts that proves that human rights are really universal, indivisible, interdependent, and therefore justiciable. We hope the views of the Committee on Individual Communications under the optional protocol to the Covenant, building on the decisions of national and regional complaint mechanisms, will provide further jurisprudence on the issue. We're still very much in the beginning. The OP entered into force very recently, and we've had some interesting cases, but we're far from arriving at the status of jurisprudence we would like. Following the standard procedure, the committee asked the UK for its position on ratifying the optional protocol, but did not get any reassurance that it was even under consideration. In the 2015 report to the committee I referred to earlier, the Scottish Human Rights Commission suggested that we ask the UK delegation to outline the steps the state party had taken to give full effect to the Covenant in domestic law and provide an effective remedy for victims of all violations of economic, social, and cultural rights in line with the Committee's General Comment number 9. Now, this is a general comment we adopted in 1998 on the domestic application of the Covenant. And it's important to refer to the date of adoption because 20 years later, our experience would advise us to be more prescriptive on incorporation. Given that the means chosen to give effect to covenant rights in national law are also subject to review as part of the committee's examination of states parties' compliance with its obligations under the covenant, the committee is now much more aware of the importance of incorporation. As stated in General Comment 9, the central obligation in relation to the covenant is for states parties to give effect to the rights recognized therein. By requiring governments to do so by all appropriate means, the Covenant adopts a broad and flexible approach which enables the particularities of the legal and administrative systems of each state, as well as other relevant considerations to be taken into account. But this flexibility coexists with the obligation upon each state party to use all the means at its disposal to give effect to the rights recognized in the Covenant, in line with the fundamental requirements of international human rights law. In other words, covenant norms must be recognized in appropriate ways within the domestic legal order. Appropriate means of redress or remedies must be available to any aggrieved individual or group, and appropriate means of ensuring governmental accountability must be put in place. Our dialogue with UK for many years now is an example of a failed conversation. Since there's no specific provision in the Covenant that requires them to incorporate the Covenant or to accord to it a specific status in the domestic legal order, states parties like the UK hold the view that other methods of implementation of the ICSCR through appropriate legislation and administrative measures ensure the fulfillment of their obligations under the Covenant. What experience has proved is that non-incorporation weakens the status and the scope of these rights, on one hand, while on the other, covenant rights cannot be applied directly by domestic courts, which restricts access to effective legal remedies for violations. Till now, and we saw this in the quiz, many economic and social rights have not been incorporated into law and policy in the UK, which means that there is no effective guarantee of an effective remedy in case of violations. A more recent example of a failed conversation was with New Zealand last March. In the New Zealand Bill of Rights, economic, social, and cultural rights do not enjoy equal status with civil and political rights. Covenant provisions are still not fully incorporated into the states parties' domestic legal order, despite the recommendations made by the Constitutional Advisory Panel in 2013. And the New Zealand Bill of Rights lacks supremacy over other statutes and legislation adversely affecting human rights, despite declarations of inconsistency made by the Human Rights Review Tribunal and the courts under the Human Rights Act. The committee appreciated the change in the posture of the recently elected government towards economic, social, and cultural rights, but regretted the fact that non-acceptance of incorporation remains unchanged, at least for the time being. Like we said to the delegation, there was a change in posture, there was no change of heart. An analysis of state practice with respect to the covenant shows that states have used a variety of approaches depending significantly upon the approach adopted to treaties in general in the domestic legal order. In a very comprehensive paper on economic, social, and cultural rights in Scotland, Katie Boyle has given us an excellent overview of the current protection of economic, social, and cultural rights and how they may be better protected in the future. And I'm sure she'll explore these options when she speaks. She also explores constitutional approaches to SCR incorporation and constitutional models and economic, social, and cultural rights. The committee often refers states to the use of constitutional provisions according priority to international human rights treaties over domestic laws. The issue has come up most strongly in recent dialogues with states in conflict or post-conflict situations. For example, the Central African Republic, also last March, where the committee reiterated that the recognition of economic, social, and cultural rights can contribute to overcome certain of the profound causes for the conflict, including unequal treatment between different parts of the country or different population groups or the grabbing of resources by a few. We further added that economic, social, and cultural rights have a role to play in the transitional justice system of reparation to victims and guarantees of non-repetition. Civil and political rights are generally included in peace agreements, but there's scarce mention of economic, social, and cultural rights, probably because they're still considered subsidiary to fundamental rights and freedoms, to be fulfilled by policies based exclusively on availability of resources and therefore subject to future economic development and the approval of international financial institutions and donor countries. Given that in some donor countries, economic, social, and cultural rights are considered as policies, or in the best case as benefits, but seldom as entitlements that entail state obligations, it is easy to understand why they are not part of peace agreements. It may be true that constitutional rights primarily set aspirational goals, but it's certainly true that rights that are in the Constitution or in a Bill of Rights are much more likely to be further object of framework laws to guarantee universality and even national plans for implementation with inbuilt accountability mechanisms. Let me give you just one example. In countries that were under fiscal adjustment programs during the austerity period, and Portugal was one of those countries, one of the first measures to be taken was to cut drastically in social spending with a corresponding negative impact on the enjoyment of economic, social, and cultural rights. But countries that had constitutionalized some or all of these rights, which in the case of the Portuguese situation was true, our right to social security is a constitutional right. So we had some safeguards in place that protected rights holders from even more long-lasting consequences. During a dialogue with the UK delegation in 2016, we indicated our assessment that if there was one right particularly subject to erosion in the country, it was the right to social security. That had a recognized impact on enjoyment of a number of other rights and ultimately on the right to an adequate standard of living. So we recommended that UK review the entitlement conditions and reverse the cuts in social security benefits introduced by the Welfare Reform Act of 2012 and the Welfare Reform and Work Act in 2016, and restore the link between the rates of state benefits and the cost of living so as to provide a level of benefits sufficient to ensure an adequate standard of living, including access to health care, adequate housing, and food. We also recommended a review in use of sanctions in relation to social security benefits that need to be used proportionately and should be subject to prompt and independent dispute resolution mechanisms. The threats to the enjoyment of the right to social security are well documented in the update report of the Equality and Human Rights Commission on Great Britain's implementation on the International Covenant on Economic, Social and Cultural Rights. And the title of the report is Progress on Socio-Economic Rights in Great Britain, and it was launched in March. And there we learned that in many cases, the level of social security benefits are not sufficient to cover the basic cost of living, which we already knew. And we also knew that the European Committee on Social Rights in January had found UK in breach of its obligations under the right to social security due to the fact that benefit levels are well below the poverty line. It is very welcome that under the social security principles, the Scottish social security principles, social security is considered as a human right essential to the realization of other human rights. That there is an idea of drafting a social security charter in broad consultation with people with lived experience of the social security system, and that a Scottish Commission on Social Security will scrutinise legislative proposals and report to Parliament and Ministers on the assessment to the extent to which expectations in the Charter are being fulfilled. They are all very good steps on the way forward, but a final step which could be taken to complete this progressive vision of a rights-based system would be the full incorporation of the right to social security through a duty on the government and public implementation bodies to comply with international human rights law. As we all know, non-discrimination and equality between men and women are essential cross-cutting principles for the enjoyment of human rights. Having economic, social, and cultural rights in the Constitution or in the Bill of Rights at a national level would also lead states, including the UK, to strengthen the anti-discrimination and equality legal framework and encourage them to enact framework legislation that will provide the overarching legal architecture for a coherent non-discrimination framework, the prohibition of intersectional discrimination, and integrated policies to combat the root causes of discrimination. Now, whilst equality of opportunity is an area mainly reserved to Westminster, it is welcome to see the Scottish Government taking what steps it can within devolved competence to advance the grounds of discrimination through the Fairer Scotland Socio-Economic Duty, addressing inequalities of outcome in strategic decisions. This clearly enhances accountability and potentially draws attention to specific dimensions of accessibility, availability, acceptability, and quality of goods and services required for the realization of economic, social, and cultural rights that are not available on an equal basis for all. I must tell you that I'm grateful to the Scottish Human Rights Commission colleagues for having enlightened me on this devolved competency issue, which I really creates a huge problem in my understanding capacity. I really don't know what is devolved, what aspects of what is devolved are really devolved, what is still not devolved, what will eventually be devolved or not. So it's like a major confusion. I'm really grateful to all of you having kind of not totally, but at least partially informed my thinking on this process. Now, there are two other important aspects. The first is the allocation of maximum available resources for progressive realization. And this is important in the context of economic, social, and cultural rights, because you often hear national delegations tell you that freedoms do not imply resource allocation. Positive obligations imply resource allocations. And really, that's not true, as you all know. But the fact that economic, social, and cultural rights are not given the status and relevance they deserve in domestic law and policy, but rather remain to be realized by fragmented programs and ad hoc support measures that generally do not comply with a human rights-based approach, this has obvious consequences on the allocation of resources guaranteed by the national budget. We know these resources are increasingly more scarce and subject to negotiation between line ministries at times with conflicting priorities. Generally speaking, progressive realization of economic, social, and cultural rights seems to have come to some kind of a standstill across the board. And again, constitutional recognition of these rights is a reminder to states of their overarching political and social contract with all those living under their jurisdiction. So this is one part of it, the allocation of resources. The second is the direct relation between the incorporation of the government in the domestic legal order and the adoption of a national human rights action plan. It doesn't always follow one from the other, but it does have a big connection. And these plans would help states to operate more strategically to ensure their human rights efforts are better coordinated and human rights progress on the ground is more effectively monitored. The response by the UK government to the committee's question on the adoption of National Human Rights Action Plan is self-explanatory. There is no plan to establish a plan covering the UK, the British Overseas Territories, and the Crown dependencies. The development and management of such a plan would, in the opinion of the government, have implications in the context of devolution as well as in the relationship between UK, the BOTs, and the CVs. However, and here comes a different approach, Scotland's National Action Plan for Human Rights, developed by the Scottish Human Rights Commission and launched in December 2013, reflects a strong commitment to the equal enjoyment of human rights, including economic, social, and cultural rights. This is a textual quote from the UK government report. So the Scottish Government, through the commitment to the implementation of the SNAP 2013-2017, has committed to explore the benefits and implications of incorporations of the UK international obligations, including the Covenant in Scotland. And it has also, the Commission has also used the SNAP as a way to review implementation of international human rights treaties in Scotland. Now, according to existing constitutional framework, the Scottish Parliament has the devolved competence to legislate, this I think I'm clear, with a view to implementing and observing international legal obligations. It is therefore within the power of the Scottish Parliament to incorporate the Covenant in relation to devolved areas, including education, housing and health, and part of social security, for example, regarding social care and disability payment assessments, if my reading is correct. So I think the Scottish Parliament and the government have a golden opportunity to implement the Covenant in a way that will ensure consistency between law, policy and practice. And I really hope that the renewed Scotland's National Action Plan on Human Rights will be a positive move in the right direction, including by strengthening the implementation of the concluding observations of the treaty bodies. I left the issue of the reform of the Human Rights Act and the introduction of a Bill of Rights to the end, simply to reiterate what has been our position for many years now, that any new human rights legislation should be aimed at enhancing the status of human rights, including economic, social and cultural rights in the domestic legal order, and provide effective protection for those rights across all jurisdictions. Effective incorporation of international human rights standards enshrined in UN core human rights treaties that are universal and interconnected is fundamental for sound, integrated and coherent economic and social policies. States that ratify our treaties do so out of their own free will and are bound by their provisions. They have legal, political and moral responsibilities towards their people, in particular those most in need of protection. So Scotland is in a privileged position to carry out these responsibilities. And we do look forward to the next report of the UK to assess how far aspirations have become reality. Thank you very much.
Yes, great. Thank you so much, Virginia. That was a thorough kind of expose around the state of both the nation and both nations, in fact, the UK and Scotland. So thank you for that. We have a few minutes for questions, not long, but I'm really keen to have that. Any questions from people, so please let me raise a hand and I will come to you. Somebody over there, who is it? Oh, Claire, yes. Okay. If you want to say where you're from as well, that'd be great.
I'm Claire McGilvery. I work with Edinburgh Tenants Federation. What's stopping us in Scotland from incorporating?
That's not for me.
So we'll come back to that, Claire, if that's okay. I mean, Virginia, you might want to make any kind of comment. Do you want to say anything?
Well, I'll wait for the discussion to see how it goes.
Okay.
On that one, I think I should be careful.
We will absolutely come back to that question. That's a crucial question of the day. So, Casey.
Hi, Casey McCall-Smith from the University of Edinburgh. Do we have any examples of states that have explicitly incorporated SHRC?
Yes, there are a number of states that have incorporated SHRC. Some of them have done it. I don't have a legal background, so I'm not perhaps the best person to. But there is this monist system and dualist system, and some states have. The moment they ratify it, the covenant becomes, in simple language, it takes precedence over national law.
Right.
But that does not mean it is incorporated often.
I agree.
But then there are states, like I said, you have these rights in their constitutions, at least some or all of them. And they use the covenant better, for sure.
Right. And that was my question, because I think what's interesting, and one of the things that we need to discuss today, is about what we mean by incorporation. Do we mean as a country adopting the entire convention and saying this is entirely enforceable, or because the monist system hasn't seemed to work, at least in my own opinion, and then making the rights incorporated through other means, so in a piecemeal approach. So that was my question, because I haven't been able to find any country that has lock, stock, and barrel said we now have ISA-SHRC as a piece of justiciable legislation, the whole treaty. So I just wondered.
No, you're probably right.
Okay.
That there's no total incorporation of a country that would say we have done it for the whole range of rights. But there are many countries that have the majority, the great majority of rights incorporated. The problem is that the covenant is not really invoked in jurisprudence. So the argument is we have them in the constitutions, we don't need to refer to the covenant. I don't think that's the truth, really. It's because the covenant just doesn't have that type of relevance in the judicial systems, and very often even judges are not very familiar because economic social cultural rights are not part and parcel of legal debate. I would say they're becoming much more important now. But even in law school, people tell me they don't really attach that much importance to economic, social, cultural rights. I can tell you in Portugal, we have, when I'm sitting with anyone on these panels, I tell them sometimes professors of international law and of constitutional law, when they speak of civil and political rights and fundamental freedoms, they have a very strong voice. It comes from the heart. And when they speak of economic, social, and cultural rights, the voice doesn't come that strong. And I think it comes from the fact that those are the freedoms, right? And these are aspirations. So that, I'm sure that is changing. Absolutely sure that it's changing, but still I think there's a lack of awareness of really what the nature, what the content of the right is. I think like what the Scottish Human Rights Commission is doing now in these workshops is really important because it builds capacity, it helps people shape their understanding. Before I've been working in the right to social security for so many years now. But it was only when I was involved in drafting the general comment that some of these issues even required for me further research after having been for years in the field. Because it's not really only the policy approach of a social security system, but then it's all the human rights-based principles that have to go into discussion. That, in the general comment, is one of the, I think, is the major contributions of a general comment to understanding of the right. It's how the elements of the right, the normative content of the right, how that enlightens your perspective of the policy.
Give my full support for that statement.
Great. Okay, anybody else? Any more questions just now? Yep.
So my name is Carla Clark. I'm from Child Poverty Action Group, but apologies, I'm from the London office rather than the Glasgow office. Virginia, one of the points that you made was that you've got the optional protocol, but there's been very little case law developed. So I think there's only been 2 decisions, but there's actually been substantive consideration as opposed to inadmissibility decisions. And so, for example, in relation to the right to social security, if you look at it in the covenant, it's very broad-brushed. Yes, even if you look at, you get more content in relation to the general comment itself. But in relation to judges, they're wanting to look at actual decisions. And I'm just wanting to know what measures, what steps can be taken for those countries who have ratified the optional protocol to try and encourage more decisions, more referrals to come through from individuals within those countries.
Carla, I think the countries that have ratified the optional protocol, the cases that have come from the Social Security, invoking a potential violation of the right to Social Security, we've been very unlucky. Because they're not admissible because of this difference between the fact and the continuing effects. Right? That was a discussion that took us maybe 2 sessions to clarify what was the fact and whether it had continuing effects or not. And that was fundamental to decide whether we would consider a complaint, a communication, admissible or not. So we had a whole bunch of communications from Spain. I think there's a a legal firm that is trying to use that as a niche for business. But unfortunately, the facts had occurred before the adoption protocol came into effect for Spain. So we were not lucky in the cases we got, right? And the one case where we took a decision was actually a very interesting case. I'm sure you've been through the jurisprudence of a non-contributory pension for a person with disability who was in prison. That was also a very interesting case. But the state was not in violation at this moment. So at that moment. So what I would say is how we could encourage the countries is we could encourage more lawyers, more civil society organizations to come up with cases that really have a strong basis for a content discussion, to clear the admissibility thing. Don't try to force that, because that the committee is extremely careful in terms of being very clear on the admissibility criteria. Otherwise, we'll be in great trouble if we do not have a consistent approach. So relating to it, the admissibility criteria, which is like a tick box actually, there is no possible room for interpretation. Now, if the cases that come are cases that have a content that lends itself to interpretation, using General Comment 19, using whatever other instruments are around, that would really help us. But we've not been lucky in the cases. There's now one which is under consideration that has been sent back to the State Party, which is also an interesting case. I think I can share this with you because it's a case that has to do with a young couple with 2 children. They're migrants, and they were evicted because they could not pay the rent of a privately rented flat. So there's no state involvement as such. However, what was clear in that case is that they arrived at that situation where they could not pay the rent because of a total failure of public policies. Those are the type of cases, that is the type of cases that I think provides this very specific hook for the committee in relation to the covenant. It's not only the right that is violated, but it is general measures that states need to take to avoid violation. And that, in the case of the covenant, is basically grounded in the complementarity of public policies. So the more cases we get that allow us to, play this out and make the legal arguments for this, I think it's going to be a win-win situation for everyone. So far, we have not really been very lucky in the cases that have been brought.
Okay, thank you very much, everybody, and Virginia. I'm going to stop that. There'll be more opportunity later, both to discuss and to ask questions. So this is not your last chance. Yeah, no, we will. Don't worry. Claire, you haven't forgotten your question. We will be having a break shortly, but before we do that, Kavita is going to literally take us through some of those standards and norms that have been referred to in this process, just so that for those of you who are not familiar, you have a chance to sort of see how that pans out. So I'm going to hand back to Kavita for this next conversation.
So after the break, we will get much more into the detail of the ways and means by which Scotland could incorporate and the different models for doing that, and Katie will go into that. But as Judith said, I'm going to give a really whistle-stop tour between now and your tea and coffee break of the basic legal norms or content of economic, social and cultural rights. I'm going to try and do this in a strong voice, despite that I'm sitting next to a global expert in this, and I have no quiz. So it's pretty dry, but I'll do my best. We decided to include this in the programme because we are aware that so many of you in the room will be so familiar with the legal standards and norms that relate to the European Convention on Human Rights, but maybe much less familiar with those that come from the Covenant. And a very basic understanding of these legal norms will assist you then to understand the obligations that we're trying to enshrine, or at least give a greater prominence to through incorporation. So I'm talking here primarily about the rights enshrined in the International Covenant, economic, social and cultural rights, in particular the rights to social security in Article 9, adequate standard of living, Article 11, the right to the highest attainable standard of physical and mental health under Article 12, and education under 13 and 14. And these obligations relating to these rights are really grounded in Article 2 of the Covenant, which states that... Oh, I've missed a slide. That states... Yeah, you're going to have to help me. Yeah. The standard rights are there that states need to... I'm going to get this wording of Article 2. I've got to remember the full wording of Article 2 of the Covenant. State needs to take steps essentially to progress the realisation of the rights in accordance with maximum available resources. Along those lines, the slide is missing. I want to talk through what these concepts mean and the implications of those in terms of how we monitor and assess compliance with the rights. So, starting off by saying that, as I said earlier, part of the significance of the rights framework is that it gives rise to corresponding obligations on states and public bodies. And these obligations are both negative obligations, so not to do things, but also they're positive obligations to proactively take action. And the formulation of those obligations that many of you will be familiar with, taken by the treaty bodies, is threefold: that we need to respect, protect and fulfil human rights. And I tend to remember this like a traffic light system. So respect rights, meaning non-interference with rights, so negative obligations. So, for example, no forced evictions. Protecting rights, meaning that there's a duty to stop others, like individuals, like private actors, businesses, from violating rights. So, for example, by regulating the private sector. And then the third duty being to fulfil rights. So a positive duty for states to take action to ensure the fulfilment of rights. And this duty to fulfil obviously comes really into the fore when you're talking about economic, social and cultural rights. And it can be broken down again further, that the obligation to fulfil means firstly to facilitate access to goods and services, so remove barriers to access goods and services. Secondly, to promote rights and how to claim them, so there's an information element that people should know their rights in order to claim them. And then the third aspect of fulfil being to provide the rights directly. So where people, for reasons beyond their control, aren't able to access the rights themselves, there's a duty to provide access to those goods and services. So the obligation to fulfil is often regarded as the hardest, because to be clear about what states are meant to do. And that's because of the conditional language in Article 2 of the treaty around taking steps to realise the rights to maximum available resources, so understanding what these concepts mean. And as I said earlier, there's been significant work done over the past 20 years to unpack those obligations and a focus on how to give more concrete meaning to those concepts. So I'm going to talk through each of those elements of Article 2.1 of the treaty, because I think understanding them tells us more what we need to know, what we need to assess to whether or not we're meeting our international obligations. So there's a big advancement in... there is Article 2. It was there. Okay. There's there now. There's a big advancement in understanding of what Article 2 means from the treaty bodies and for other international experts. And it's said now that you can see it as there's two sort of relatively distinct, although overlapping, components of that. There's obligations of conduct, which is what you see on the right, and there's obligations of results. So conduct means that government must take action. It must, as the treaty says, it must take steps, and that's on the right-hand side of the screen. And importantly, these obligations of conduct are immediate. There's no delay to that. And then on the other side of the screen, you'll see there's obligations of result or outcome, which means what the states do must actually achieve the better enjoyment of rights. So we need to see, as the treaty says, the progressive realisation of the enjoyment of the rights. So improvement in the rights over time. So that's subject to this progressive realisation concept. So the obligation to take steps by passing laws, developing policies, formulating budgets, all of which need to take into account people's rights. These obligations are immediate, not subject to progressive realisation, and happen immediately. But you need to do both. You need to take action, and of course you need to achieve results. So it doesn't matter if you've passed hundreds of laws if they don't actually see an increase in the enjoyment of rights on the ground in people's lives. So when analysing if a state is meeting its obligations on the fulfilment of the rights, we're interested in both of these dimensions, both what a state is doing or not doing, and whether it's having an impact on the outcome on the ground for people. So I'm going to start on the results side and what kind of results governments are expected to achieve. Firstly, on the results side, there is the concept of non-discrimination, which clearly cuts across human rights law in lots of ways. It's a huge area of international law as well as domestic law. So this is just the absolute basics in international law terms of its main elements. So as an outcome, one of the things the government is expected to do is to eliminate direct discrimination in law without delay, and as well to eliminate de facto or indirect discrimination, which means that a law might not discriminate on the face of it on paper, but in practice some individuals or groups can't enjoy the realisation of their rights as equally as others. And that needs to happen as speedily as possible, which is the language of the treaty bodies. So it also recognises that positive measures can be taken to end discrimination. That's that concept. Another really important concept when it comes to economic and social rights is the concept of minimum core obligations. So this is another result, if you like, that governments are expected to achieve to satisfy what's been called the minimal essential levels of each right. And this applies to all countries across the world, regardless of the resources that they might have at their disposal. And conceptually, that's quite an interesting idea, but it's obviously quite debatable as to what does that actually mean. And there's literally, like books written on this subject and scholars and experts and judges examining this all the time. What does a minimum core actually look like, where they deliberate on that question? And there's some efforts to define that much more clearly. So the general comments in relation to each of those rights give a lot more detail on how to define a minimum core. But there's huge scope for defining this in a local context through participation and consensus at a domestic level, drawing on data and evidence. So looking at what are the right indicators, benchmarks that can be used to inform that local level consensus as to what a minimum core of a right might look like.
Can I interrupt you?
Please.
When I first started as a member of the committee, one of the things I really couldn't understand is the notion of minimum core. Because core to me is core. There's no minimum or maximum core. And I still remain to be enlightened, honestly. All my colleagues have given me brilliant legal interpretation, but I still fail to see. I don't think a core has a minimum. If it's core, then that is it. You can't then make a difference between core, minimum, medium, and maximum core. It's just not possible. But this is an ongoing discussion, and when I hear you so articulate about a minimum core, I couldn't resist. I said,
okay. So we'll call it just a core. I'm not going to say minimum anymore. Okay, good. Yeah, it's the language. But one of the reasons it's a useful concept is that it provides a higher standard of proof on the state to show that they're taking every action possible to meet that essential level of the right. And it creates a presumption that states are violating international law if they're not meeting that core of the right. And to argue against that, they would have to show that every effort's been made to use all the resources at its disposition to prioritise those minimum levels of the right. So whilst rights might be only one element in decision making, where there's trade-offs in budgets and in policies, that minimum level has to be given absolute top priority in those trade-offs, if we can identify what it is. So another concept to be familiar with when we're talking about economic and social rights is that concept of progressive realisation and non-retrogression. So the idea of this is essentially that obviously not all countries have the same resources at their disposal, so it would be unfair to expect Scotland and, say, Malawi to have the same health outcomes, and recognise that there needs to be investment in economic and social rights over time, and it takes time. But what we want to see is that improvement over time. And what the committee said is that this needs to be as efficient and expeditious, so as fast as possible. And an important thing to consider in relation to this concept is measurement. So how do you know whether there's been progress over time? And for that, again, you need to have the relevant data, both quantitative and qualitative data, to understand whether or not these rights are really, truly being progressed over time. And we sometimes don't have that. And of course, the opposite of this concept of progressive realisation is non-retrogression. So if things are moving backwards, if homelessness is increasing, if poverty levels are increasing, this is a red flag, and again creates that higher standard of proof for the state to show how they're doing their best to advance rights. And the language that the committee uses is that states must fully justify these types of policies and give criteria. They give some criteria as to what that justification entails, which are on the screen. I won't go into. So a lot of work around the enjoyment of economic and social rights in the context of austerity has meant that we've had to grapple more with questions of when is it justified for the level of the enjoyment of rights to decrease rather than increase when countries are in financial crisis. So these three concepts, non-discrimination, minimum core and progressive realisation, relate to the obligation of result. So that's what states should be achieving. And now we're going to look at what the obligations of conduct are. So what are the steps or the actions that need to be taken by the state? So there's this obligation to take steps. And the language in the treaty itself states that these steps can be financial steps as well as social steps, educational steps. But of course, it's one thing to take these steps if it's not improving the situation on the ground, then they're no good. So this needs to translate then into proper goods and services and infrastructure to support the enjoyment of the rights in practice. So in relation to those goods and services and infrastructure on the ground, the next norm that we often talk about in relation to economic and social rights is what we refer to as the AAAQ framework. So if you think of this as basically criteria for assessing those goods and services, whether it's schools, housing, healthcare, food, etc. So the AAAQ standing for the first A being for available. So those goods and services need to be available in sufficient quantity. They need to be accessible. So that's physically, that's economically, and without discrimination. Thirdly, they need to be acceptable, both socially and culturally acceptable, and they also need to be of an adequate quality. So these are kind of quite familiar concepts that those that are assessing policy might use, and it's a human rights framing, if you like, of that assessment. The final norm, which is really important, as Virginia flagged in her speech, that really differentiates economic and social rights in lots of ways from civil and political rights, is this qualification around the steps being taken to be made to maximum available resources. So civil and political rights clearly don't really say very much about resources, even though in reality we know that civil and political rights cost a lot as well. So having an effective court system or criminal justice system clearly costs a lot of money, but that's not dealt with particularly in relation to civil and political rights that are not subject to this qualification, really, that economic and social rights are subject to maximum available resources. And in the covenants, specific language is used around the use of resources, and it's through the interpretation of that concept there's been some progress in unpacking of what it means. So first of all, we need to look at the use of existing resources and whether they're equitable, whether they're being used effectively. And we also need to consider not just how the resources are allocated, but how big is the overall pot. So ask questions about whether or not the state could be doing more to generate resources to invest in economic and social rights. So part of their obligation is essentially to generate as many resources as they can to invest in economic and social rights. So that means that we need to consider fiscal policy and taxation, as well as budgetary decisions. So it's on this basis that the Commission is currently undertaking a project around human rights budgeting, as a way of analysing budgets to see the extent to which they take into account rights realisation and whether maximum available resources are being deployed. And the final point in relation to resources is that it's not just limited to money and finance. It also includes human resources, natural resources, technological resources. And again, this is an idea which is developing more and more, and one that we drew on in relation to the debate around land reform in Scotland. Okay, so that's an absolute whistle-stop tour before your coffee break, which I think we might now be late for, of some of the norms that relate to economic and social rights. And I think it's really important to say that these are not static ideas, that they are subject to ongoing elaboration and evolution and clarification by the UN committee, but also by those using the concepts, by civil society, by parliaments, and crucially, as we'll see later this morning, by judges in their national courts and jurisdictions all over the world where these rights have become justiciable, and Katie will talk about that after the break. So these concepts have, to different degrees, they've been used and elaborated on in jurisprudence globally to assess economic and social and cultural rights violations. So I think that's me.
Great. Good. Okay, so that was indeed a whistle-stop tour of the standards and norms, and from my perspective, and I was relieved to hear Virginia didn't come from a legal background. I thought good solidarity in not coming from a legal background. From my perspective, actually, that you don't need a legal background to understand what those standards and norms really mean. And in terms of promoting a language and a framework and an analysis of the realisation and implementation of rights, that was eminently comprehensible and actually relatively simple. So I was pleased to see that from my perspective. Anyway, now is a chance to digest some of what you've heard. So we'll give you a break for 20 minutes, and I'd like to see you back here at 11:30. Thank you very much.
One more thing. So we're going to put back the Mentimeter screen, so feel free to log back in with the code, which is going to come back on the screen in a moment. Yeah, 562334. And if you've got any comments, because we're aware there's not a huge amount of, there's a lot of content to today, not a massive amount of time for lots of dialogue. So please do post any comments, reflections, thought that you have up on the board, and those comments will be visible to everybody, and we may be able to come back to them through the day.
Thank you.
Great.